So that's pretty much it in a nutshell when it comes to trademarks and copyrights and some business strategies. Again, the main thing I would say, make sure you set that proper legal foundation. It will definitely help you in the long run. Again, it's an investment that it's an important investment. Definitely should say that. It's definitely an important investment for you, for your business, for your artwork. Again, you guys put a lot of time and energy and effort into it. You want to be sure that it's protected, especially in this day and age that we live in. Are there any questions?
I have a question.
Sure.
About the intent to use application.
Yes.
How long is that good for, and
Yes.
what's the fee for that?
Sure. So the intent to use application will be the same fee, the $250 that I mentioned for the trademark office. The intent to use application, once you submit it, it kind of goes through that same process as I stated. You submit the application, it's assigned to an examining attorney. Right now, it's taking about 7 to 8 months for an examining attorney to actually look at the application. Once they look at the application, they will send you something called a notice of allowance, basically letting you know, hey, you can move forward with filing your trademark. Have you been using this in commerce? And then you will submit to them a statement of use, basically saying, yes, like I said, it could be 8 months that have passed. Yes, we finally have been using this in commerce. Website is set up. We're selling this item. Or if you have not started using it in commerce, you can ask for an extension. And they can give you a 6-month extension. So I believe you can ask for an extension right now. I believe it's up to 3 times, where you can ask for an extension until you start selling those goods and services within commerce.
Is that mandatory? I mean, intent to use, then you go to the formal phase, or you can just skip the intent?
Oh yeah, you can. Yes, there's 2 applications when it comes to trademark. There's the basically that you're currently using it in commerce. That's the regular trademark application, and then the intent to use application. The intent to use application is just a placeholder. Say you're not ready yet. You're still working behind the scenes of your business, but you don't want someone to take that name. You don't want someone to take that logo. You're kind of letting the trademark office. So I'm putting this placeholder because I'm working on the behind the scenes now, and I don't want someone to take the name. But if you currently are selling goods and services within commerce, you're able to file the regular trademark application.
So let's flip. Somebody files an intent to use. You said it goes to the standard 7-year.
Not 7, yeah, 7 to 8 months. Currently, right now, it's taking about 7 to 8 months for the application,
to get approved.
not approved, to get assigned to an examining attorney.
Okay.
So the examining attorney is the attorney that works at the trademark office. Because once you submit the application, it gets assigned to the examining attorney. They look it over. They're the one that's going to say, yes, this can be approved, or no, this can't be approved. Because they've been, over the last several years, especially during the pandemic, so many people have started businesses. So many people are more privy to the importance of getting a trademark. So they're backed up. Years ago, it would take about 3 months or 2 months for it to be assigned to an examining attorney. But right now, it's taking about 7 to 8 months for them to even look at your application. So once they look it over, with the intent to use, they'll send you something again called the notice of allowance, basically saying you are able to move forward with filing this trademark. But then you can let them know, hey, I'm not ready yet. I'm still working behind the scenes. I need an extension.
Okay. And I guess the intent, so if somebody else filed something that I wanted to use, and I'm sitting around waiting to see if theirs is going to move forward or whatever the deal is, because I really like that, and we had the same idea.
Yeah. So as far as you filing before them, or they're
No, waiting and saying, how do you say, I would like to get that from you if you decide
or not to use a
go
name?
on. Yeah.
Okay, so with that, it's the same as I stated. There's that whole opposition period. So, say for instance, if someone submits an intent to use application, you like that name, you go look up that name, like, man, that's a good name, but I see that there's a pending 1B, because with the intent to use application, it's a 1B application. It's a 1B application. So you kind of have to do your due diligence and seeing where it is. If you go online, I'll show you where it is in the process. If it's been assigned to an examining attorney, if it's at an opposition period, where I stated that 30-day, once they put it in the trademark newsletter, there's that period where you can kind of, well, with that situation, you really want to be able to oppose it, because if they file first and they've been using the name before, you don't really have a chance to oppose it. But say, for instance, if they submitted an application, they're like, you know what, I actually don't want to use this name anymore, and you see that they're not using the name, that's when you can quickly go ahead and take that name.
How do you see that they're not using it, I guess, is my thing, but just looking at on the.
Yeah, so if you go on the USPTO website, again, you can look up a mark, and once you look up the mark, you can see when the person filed the application, you can see, basically you can see everything. Who's the attorney, who's the person's name. You can even reach out to that person like, hey, I love this name. Some people may get into maybe a licensing agreement with you once they do get that trademark. Like, oh, you like saying maybe I can sell this trademark over to you. So that is an option because you're able to see all that information on the application.
So I filed for a trademark like 5 years ago,
Okay.
and I just got a letter in the mail to renew,
Yes.
and it was $1,000, and I haven't paid yet, or I haven't really sent it back yet.
Okay.
And I was wondering, like, what happens, like, or how long do I have to refile for the 10 years, I guess it is.
So you filed it 5 years ago, you said?
Yeah.
Okay.
For
So
my first time, and I filed online, and I paid the $250 or whatever
Yeah.
it was, and then, like you said, it's 10 years after that when you refile, right?
so the first time that you have to renew it is between the 5th and 6th year. So basically you have to, whatever that date was for the 5th year, it's up until the 6th year. So say for instance, if you filed, we'll use today as an example, you filed today. You have between today and next year for this date to file. So basically you have like a year window to file between the 5th and 6th year. Yeah, just make sure you do it so you don't, lose your trademark.
So why does the process take like 7, 8 months? Is it just a backlog? Or
Yeah, that's pretty much it, backlog. Again, because with
applications?
with the pandemic, so many people were at home, so many people thought of different ideas of businesses, and again, people didn't really know the importance of trademark before, but then now with social media, you're hearing LeBron James talk about trademark, Kim Kardashian talk about trademark. It's even in politics. Not too long ago, there was a whole situation that went down, and one of the politicians, she trademarked one of the, a combative term that was stated to another politician. So because of the awareness of trademarks and because people, again, during the pandemic, everyone was home, everyone was starting businesses, that's why there's a backlog now. And it's taking 7 to 8 months for it to be assigned to an attorney.
Do the copyrights take as long as the trademarks to go through, or is that like a separate?
Yeah, so separate office. So with the trademarks, it's the USPTO office.
Right.
And with the copyright, it's a lot quicker. It's about 2 to 3 months. And you can also expedite it. If you need to, and with the I believe I'm trying to think how long, if you expedite, I think it takes about 2 weeks or so if you expedite it, yeah.
Because I'm wondering if you copyright every single work, like before you like even post it, I'm wondering like how long, but since you're saying you could expedite it too, I guess it wouldn't be so bad. Since nowadays, like you said, with social media, like people are putting out work constantly, artwork online, photos and things. So I'm wondering, is every artist copyrighting every work that they're posting?
All of them are not, to be honest, because again, with copyright, you receive automatic copyright protection. So if you create something right now, you automatically receive protection. It's just you won't be able to bring a lawsuit. Like if you want to bring a lawsuit in federal court against someone for copyright infringement, you have to be registered with the Copyright Office. So that's the only difference. Yeah.
I have a question.
Sure.
So say you file for a copyright or a trademark, and in that period that you're waiting for it to get approved, someone else uses your work. Would the date of your copyright or trademark being active be the date that you filed or the date that it got approved?
So once you get, I always tell clients, once you get the application in, the sooner the better. Because you'll have some type of recourse against that person because you can let them know you have a pending application. So you can send, I don't know if you guys are familiar, there's something called a cease and desist letter. The cease and desist letter, basically you're sending to the person and letting them know, hey, this is my work. And if you have a pending application, you can say, I have a pending application with the Trademark Office or I have a pending application with the Copyright Office. This is the number. I'm asking you to immediately stop using my work. So that's something that you can have. You do have some leverage, even though you haven't received an approval, but you do have a pending application, so you can submit it that way.
You mentioned free use earlier with copyrighted material.
Yes.
How does satirical work or homage fall within that area?
Yeah, so when it comes to fair use, again, there's that four-pronged test you have to look at. So with satire, you are able to say that's fair use. As long as you're not taking the complete work of a person. Again, I use an example of maybe like a 30-minute video that someone had created and you're kind of, you recreated, kind of created a satire version of it. So it's depending on how much of that 30-minute clip did you use, how are you using that work, again, is it affecting the person's market value? So it's a very subjective test, I would say.
What's your take in the digital world we're operating in? NFTs, I think that's NFTs were.
Okay, but yeah. I would say my take on the digital world, it's changing so rapidly. We're trying to even wrap our heads around it, in the legal field because, there's been talk like, oh my gosh, with ChatGPT, are we still gonna need lawyers? So there's just so many things that is happening at a rapid pace. So honestly, we're trying to embrace technology and we're trying to let our clients know, again, just make sure you have the proper legal foundations for things that you can have the proper legal foundations for. Again, unfortunately, with AI generated work, you can't copyright that right now, but who knows what that will be in the future.
The copyright and trademark issues you're talking about only apply to the US. If somebody in Europe or Asia was to use your work, what recourse would you have?
Well, you can actually file. There's in regards to the trademark, this has been called the Madrid Protocol, where basically there's several different countries that you can kind of submit one application to and have protection over there as well. So you can actually file within those countries, and you can also send a cease and desist letter if someone is using your work in another country.
What's the Madrid Protocol?
Yes, Madrid, but when it comes to trademark applications.
Okay. And that's for overseas?
Yes.
Okay.
There's several countries that's part of the Madrid Protocol and you can
Okay.
submit the application to, but you have to, so when it comes to that, you have to file first in the US unless you get an attorney overseas to do it for you. But a lot of times, I have clients here where we'll file first in the US and then we'll file with the other countries so they can get protection overseas. Especially if you're selling things, online, e-commerce, you want to be sure you have that protection.
When filing for copyright for a group of images,
Yes.
is there a limit to how many images you can put in that group?
No, there actually isn't a limit. You can do a whole published, unpublished work. And like I said, I highly recommend it. It's a lot easier and you save money that way because if you're filing each image separately, that's going to be a separate fee for each one. I believe the basic fee is $45. So can you imagine paying $45 for each image? And you can do a group of work together where you're paying, between $55 to $85. You're saving a lot more money. And it's just a lot easier process.
When it comes to printing, we've run into it a lot where people say, oh, I bought this painting, I'm going to make prints of it now and sell them. I believe that in that case, the artist would retain the reproduction rights and the person who physically owns the piece
Yes.
isn't able to do that.
Yes, so they cannot do that. That definitely is copyright infringement because you do not own that work. Whoever the artist is, they are the owner of the work. So again, unless you had permission from the artist or if they licensed it out to you or they transferred their copyright to you, that's the only way that you would be the rightful owner. If it's not that situation, you just kind of want to reprint it and resell it, that's when an issue arises and you can definitely be sued for copyright infringement.
What if you commission?
If you're commissioned for it?
No.
Sorry.
You bought a piece of art.
Yes.
You're buying the art, but you're not buying the copyright or you're not buying the ownership of the rights to reproduce it. But what if you were the person that said, I commission you artists to do this for me?
Okay, so almost like a work for hire. You hired someone to create something for
Do
you.
you own that?
They, again, with the work for hire, it comes into a situation, if it's not, it's a little bit, I wouldn't say muddy, but there's several different progs when it comes to work for hire. If it's a situation where you're an independent contractor, they kind of look to see, okay, who's the rightful owner? A lot of times it's the person who actually created the work. That would be, not created the work, the person who actually asked you to create the work, that would be the rightful owner of that work.
The
Unless
person
they would,
that asked,
yes,
who did say, hey, artist, please paint this for me.
yes. They will be the rightful owner. Unless there was a contract in place, because again, it's considered a work for hire. And again, there's several other things. Is this considered, independent contractor? Was this within an employment situation, employer-employee situation? So there's several things that you have to consider to see. But for the most part, it's a person who asked you to create it. That is the rightful owner. I actually had a situation like that where there was someone who asked one of his friends to write a book for him. And, everything was going fine. They didn't really have a stable contract in place. Of course, issues arose. So you really have to be careful with things like that, where the person who asked him to write the book, in that situation, because the contract was not plainly stated out, it would have been the person who wrote the book that would have been the author, but because they didn't have a proper contract in place, it was the person who asked them to write the book was the author. So basically he was complaining. He said, I told you to write this book, I deserve the royalties. There was a lot of back and forth and who was the rightful owner of this book. So it's so important that you have a proper contract in place, because if they had a proper contract in place, it would have detailed like, okay, this is a work for hire, I'm hiring you, but I am the owner of this. Like, you want to make sure you have certain language in that contract so issues don't arise.
So how does the copyright transfer apply to that example you just shared?
The copyright, so the person he hired to write the book, he could have had a copyright transfer in place, basically stating that he is transferring the rights over to him.
The person who's doing the artwork or the person who commissioned the work?
The person who commissioned the work.
Okay.
We have sometimes people who get in this situation where they want to license their work, or somebody's interested in licensing their artwork and they have no idea what to charge for it. Would you, legal representation, be able to help guide them in that area?
I'd say yeah. Of course, one thing that we'd have to look at is, what is, I guess, the market value, what's out there, what's the median range for whatever you're selling, comparing it to other pieces of artwork, depending, different things that go into it. So that is something that an attorney could help with, kind of helping you do that research, figuring out, okay, what should I charge this person, and seeing what exactly is out there for that. There's no further questions. Thank you guys so much for coming tonight. Hopefully you were able to learn some information. And of course, you can contact me. Again, the name of my firm is K&A Law Group on social media. So make sure you guys follow. I always share some information in regards to copyrights, trademarks, and so forth. So at least you're able to get some resources that way, even if you're not ready to move forward into it.